This morning's session is about serious incident reporting. It's an obligation that's been with trustees since 2006 or 7, but came in without much fanfare, and the Commission really didn't seem to focus on it very much at the time. But since the Oxfam scandal in Haiti in 2014, we've seen the Commission get more and more exercised about the serious incident reporting regime. And of course, what they are now doing is really focusing on the way in which trustees engage with the process. And there is an art to serious incident reporting. And this morning, Kate and I are going to talk you through that. I lead on safeguarding, and Kate is an associate in the charities team, and hopefully between the two of us we'll be able to explain a little bit more about the obligations and the process, and we'll also be able to answer any questions you may have. So if we move on to the next slide, please. In particular, we'll be talking about what's a serious incident. It's not necessarily a defined term, so we'll be giving some guidance on that. We'll be talking a bit more about the Commission's expectations, and then the practical things for you about how and when you should report, why you should report, and dealing with some of the nuance, in particular in relation to safeguarding, but otherwise too. Okay, so I'm going to hand over to Kate now, and I will come back to pick up some safeguarding related aspects later on.
Thanks, Tabitha. Could you just have the next slide, please, Tamar? So, as Tabitha mentioned, we're going to talk about serious incident reporting today, and so I guess, why are we here? Why is it important? As Tabitha mentioned, it is something that kind of came in without a huge amount of fanfare, but in recent years we've seen a lot more focus from the Commission around serious incident reporting and making sure that charities engage with that process, and our trustees and those working in charities are aware of those responsibilities. And we'll come on a bit later as to why that is and how that feeds into the Commission's sort of wider regulatory role. But essentially, I think the starting point is that the Commission requires charities to report serious incidents to it. And it defines serious incidents within its guidance. And the main piece of guidance is the how to report a serious incident, which actually isn't just the how to, it goes through a lot more than just that. But within that guidance, it defines serious incident as a serious incident is an adverse event, whether actual or alleged, which results in or risks significant harm to your charity's beneficiaries, staff, volunteers, or other people who come into contact with your charity through its work, loss of your charity's money or assets, damage to your charity's property, or harm to your charity's work or reputation. And it's quite a wide-ranging sort of definition of what might be considered a serious incident. And actually, one of the key points I think are actually in that preamble is it includes whether it's actual or alleged, or whether it actually results in or risks significant harm. So it's not just incidents that sort of have occurred and it's quite clear they have, and there's a factual basis for that and evidence, and they have actually resulted in some form of harm to the charity or its beneficiaries or the general people it comes into contact with. It also encompasses those risks, and so it means that trustees need to be aware of sort of that risk, the risks that are being presented to the charity when they're thinking about serious incident reporting. It also uses the word significant, and this is where sort of determining what is significant can be quite tricky for trustees. And we'll talk a little bit more about thresholds and some sort of tips and hints about when you might be able.
Right, I'm going to kick off again. So what I was talking about is what a serious incident is. And so essentially we're talking about actual or alleged, or which results in risk or significant harm to your beneficiaries and other people who come into contact with your charity through its work, loss of your charity's money or assets, damage to your charity's property, and harm to your charity's work or reputation. And I was generally just saying that's quite a broad definition, and quite a lot of sort of incidents and things that happen on a day-to-day basis in a charity may well be caught by this definition. And also can be quite tricky in determining what is significant. And significant, the Commission says, is taken within the context of your charity, taking into account your charity's staff, your charity's activities, your charity's beneficiaries, your charity's finances and resources. And so we can see there that can vary quite greatly between charity to charity in determining what might be significant. And we'll pick up later around some sort of hints and tips and some kind of guidance that can help charities and charity trustees in thinking about what might be significant and meet that kind of threshold that the Commission expects. So if we could just move on to the next slide. Thank you. So there are some sort of main categories of reportable serious incidents, and they kind of fall into these categories here. So protecting people and safeguarding incidents, which is what Tabitha's going to pick up on a little bit later. Financial crimes, large donations from unverified and unknown sources, other significant financial loss, quite a broad one there, terrorism or extremism, and other significant incidents, so the mop-up criteria. I think at this stage, it's probably also worth noting that while there's an obligation to report to the Charity Commission, there can also be an obligation to report certain incidents to other regulators and other external third-party agencies. And that shouldn't be forgotten when thinking about serious incident reporting. So for example, criminal activity should be reported to the police, might be Action Fraud, the National Crime Agency. You might have other regulators that reports will be made about too, so such as the local authority, the Care Quality Commission, the ICO in the event of a data breach. And actually, the Commission will expect you to have thought about those reports to external regulators and to the police or any sort of agency which will look at investigating any potential crimes. And it's clear within the serious incident report that it will expect you to have considered that at the outset and explain why, if those reports to external agencies, why they haven't been made, if they haven't been made. And so I think that's something that's important to bear in mind when you're thinking about serious incident reporting, is actually thinking about, do I need to also be reporting this matter to another agency whose responsibility it is to sort of investigate that or to actually regulate that specific type of incident. If we could just go on to the next slide, please. So when we're looking at the different types of incident, the first example given is one of financial crime. And that can include things such as fraud, so identity fraud, someone purporting to be somebody who they're not, things like theft, something as simple as theft of charity property, or more wide scale theft of cash or assets, and also cybercrime, which can go up to quite sophisticated systems employees, whereby there's often a data breach or some consistent phishing that takes place, and it's actually viewing the data as a very viable and real asset of each charity's. It's not just the financial loss that we think about when we're thinking about financial crime, and when we're thinking about the potential harm or risk of harm that it's had to a charity. It's also thinking about potential reputational harm, or the potential adverse public media interest there might be. And also the Commission will be interested in where incidents have resulted in some sort of public outcry or may risk public trust and confidence in the sector as a whole. So it's important to think about that when you're thinking about any kind of financial crime, and think about it in the context of the charity. And so that will have things like the size of the charity will be relevant, the size of the crime, some small sort of one-off theft from a charity shop may not well be reportable, but some form of larger scale theft may well be. But likewise, if you are running a relatively small charity, the financial sort of level will vary and its impact will vary. So as I said, that there's no financial kind of limit on this. There's no sort of you have to report something where you've had a loss of £10,000, £5,000, £25,000, but it will always be looking at the context of the crime and what's happened. And also things that you might also want to pick up on are whether incidents have happened repeatedly, who was involved in the incident. So if, for example, a senior member of the charity's employees has been involved in some form of ID fraud or has been involved in some form of kind of theft, then that is often going to be more significant than whereby somebody who's not associated with the charity has been involved. And if you have multiple sort of cyber attacks or multiple data breaches as a result of cyber attacks, then it's also worth thinking about that and thinking about spotting patterns, because that itself may indicate that there's weak systems in place, and that then may well lead to something being more significant than not. And there is an overlap with the next type of sort of general category of serious incident in thinking about unverified and suspicious donations. And that is that charities can be at risk of money laundering and can be targeted by money launderers. And that's why it's key to have in place proper due diligence checks and making sure you're carrying out appropriate checks on any large or suspicious donations that may come in. And it's not just money laundering, it could also be that a donation is made up of proceeds of crime or some form of tax avoidance scheme. And so charities are seen as at high risk for that type of activity. And so it's important to have checks and balances in place to make sure that you're able to spot risks where you are receiving donations from members of the public or members of sort of your wider network. In terms of unverified and suspicious donations, the Commission gives a guide of £25,000 or more in terms of whether that would be significant enough to report. But again, this guide isn't an absolute line. This isn't a black and white rule. The Commission asks all charities to consider the context of the donation. So for some, a smaller donation is going to be much more significant than for others. And it's those types of decisions that will need to be thought through when you come across some form of unverified or donation from an anonymous source, and its size will be relevant to the size of the charity. When you're reporting an unverified or unknown donation, one of the things the Commission will be looking for also is that the checks and balances and due diligence have taken place prior to receipt of the donation. And that really is a theme that we'll see throughout the serious incident reporting regime. It's the Commission's focus on, well, what has the charity done? And have you put in place appropriate measures in order to guard against such a significant incident? Or whether or not you need to sort of take into account and review and have any lessons learned from a particular incident. But we'll come on to that when we look at how you might report a matter. And then we look at other significant financial loss. Yeah, this is quite a broad term, and it just seeks to really pick up on all sorts of the risks that may well play into a charity and pick up on anything that the Commission hasn't really thought about setting out in detail. And the types of things here may well be sort of court claims, so any claims against the charity or that are being taken by the charity which result in a risk of loss of legal fees or damages, things like fires or floods at charity premises, any fines or penalties from other regulators, so HMRC or the ICO. And the key thing to think about here is whether that financial loss threatens the charity's ability to operate, or means that its reserves will not be significant to cover the loss. And so there it's really thinking about, well, what is the impact on the charity and ultimately on its beneficiaries of this financial loss? And that will vary from charity to charity again. But again, the Charity Commission here state that if it's £25,000 or more, it should be reported, or if it's in excess of 20% of a charity's income. But again, this isn't a hard and fast rule, and it really does need to be taken in the wider context of the charity when we're thinking about what we report and what we don't report when we've got some form of financial loss. But also, I think key to pick up here that it is also a risk of financial loss. So we could see occasions where court claims where have large damages potentially attributable to them will be a risk of a large loss to the charity, albeit we might hope that that doesn't actually result in that loss. I think if we can just go on to the next.
Okay, so
Slide,
I've
please.
just got a couple of
Of
questions
course, Tabitha.
that's been asked in the slides there, which is, do you have to record all donations or just suspicious ones? So if it's a donation, someone you know, you're expecting it, but it's large, is that reportable?
So I don't think, I mean, if it's the key about the donations in terms of being a serious incident is that it's that unverified or unknown source. So if it's somebody you know and you've carried out sufficient checks, then that's not necessarily reportable. I think the point there is that there should be a system in place whereby you are able to satisfy yourself that you know where the source of the donation is coming from. You have enough information about that individual to be satisfied that it's not coming from, I don't know, proceeds of crime or something. That's quite a sinister example, but it's that sort of quite formulaic approach really in terms of thinking it through and assessing the risk to each donation and making sure that you'll have a proportionate checking system in place based on the risk for the donation. So somebody you know who's had a long-standing relationship with the charity and you are happy that it's come from them, then it's likely to be much lower risk than something, say someone comes out and says, well, actually I'd like to donate £100,000 to your charity, I don't want anything in return. You've never heard from them before. That is all, that kind of information is going to inform your perception and understanding of the risk of that donation and inform what you ask them for. And it might well be that you go through a due diligence process, you get ID, you check, you know, their history and what their working environment is, and you run a check on them to make sure they're not on any lists anywhere, and are happy that that donation is then from a verified source, and you're happy about that, how that donation is being made and for the reasons it's being made for. And then that itself is not a reportable incident in terms of a serious incident. I hope that helps in that point.
I think so, and thank you. The other question, and I know it's one that we're commonly asked, is what about situations where there's perhaps a large claim, like you referred to a moment ago, but it's insured. So does insurance cover for a financial loss impact the reporting duties to the Commission? I
mean, I think it also, that's where you would have to take the context into place. I think it might not fit then under what we see as the other significant financial loss. If you're happy that your legal fees and the potential damages are going to be covered by your insurance, and that is clear and not under any kind of dispute, then that might not necessarily fit under your financial loss header. But you'll also need to take into account the wider context of potential reputational fallout from that, and any risks around that insurance cover and it not actually covering your full claim. Often if you're sort of on a borderline situation, we would think, maybe go for reporting than not reporting, but ultimately that is a decision for the trustees to make.
Thank you.
Great. So if the next sort of couple of categories of incidents are links to terrorism and extremism, I think relatively clear in itself. It's this idea that a charity may be, through its activities or the people it works with, open to allegations or evidence that there is terrorism, links to terrorism and extremism, and that should be reported. I think that's hopefully relatively self-explanatory. I guess some things that you might not think about in this context are where you might invite certain speakers to events or have sort of external third parties involved, and actually being aware whether they are sort of speaking about extremist views and they themselves have links to terrorism. And some charities will find they operate in this close to this field than others, depending on the types of activities they carry out and what they're furthering. How is a terrorist group defined? I think we would, actually, it's not a question I've been asked before. Tabitha, I don't know if you have any thoughts. I think, a lot of it links to the law around terrorism and the prevent duty that I think applies to most sort of school establishments. But I don't know if Tabitha, you have any extra thoughts?
There's another question, Chris, that you've asked, which is it advisable to take an approach of if in doubt report? Absolutely. and that will apply to the definitions in terms of terrorist groups. I was just checking the guidance actually to see if it had a definition. I suspect it won't.
It talks about banned organisations.
They just talk about terrorist groups. So it will be those who have been identified by the government or through local safeguarding partners in relation to that. And as we've just said, if in doubt, report.
So then we talk about other significant. You've seen the links to Russia there, and I think, I mean, it is something that the Commission will be alive to. So the question is, what about links to persons who might have links with or are Russian oligarchs? I think, again, this is something that's evolving, and it will very much depend on the context of that link. So if we're talking about financial links, I think it's clearly something that is a risk to charities that may well need to be reported, but it very much depends on the context of the facts of that situation, because it might well be that you just have someone who has a link and it's relatively remote and it isn't impacting on the charity's activities or resulting in a risk or a significant risk to the charity itself. So we talk about other significant incidents. Again, this is like a mop-up clause. So the examples given by the Commission are, you discover that someone is disqualified as a trustee or as a senior management, and that refers to legislation. And so that may well be where someone's been appointed, and then you later find out that actually they, for whatever reason, bankruptcy, insolvency, or some form of criminal charge means that they're not, they're disqualified from acting as a trustee. Insolvency or withdrawal of banking services. So that's where the charity may well be at risk of insolvency, or for whatever reason the banking services have been withdrawn. That obviously will have a very real impact on charities' ability to operate. So I think you can see quite there why that would be a serious incident. Police investigation or investigation by another regulator. Now here we're not talking about where, for example, if you're subject to inspections by regulators, so for example, in education by the ISI, the Independent School Inspectorate, or by the Quality Care Commission, if in sort of a care home setting. So if they're just regular inspections, the Commission doesn't need to hear about them. But if you've got some form of failure or later investigation, then that is likely to be a reportable incident in terms of a serious incident to the Charity Commission. And also we will often see where the information is shared between the regulators. So it is advised at that point to make a report. You might have major governance problems. And so this refers to, for example, where you might have a mass resignation of trustees or a mass resignation of senior staff that's going to have a real impact on the charity's ability to operate. A trustee or employee is subject to criminal proceedings. Again, it's going to be relevant. There is the context and how senior that person is and how that may impact their role and whether or not there's any connection with the activities of the charity. Significant data breach or data loss. So this is where we talk about sort of data breaches and where it may well then overlap with where we see cybercrime, which often involves some form of data breach. And the examples given from the Commission here are things around if you've made a report to the ICO, you've deemed it significant enough to report to the ICO that you then need to report onto the Charity Commission. And it may also be an incident involving a partner organisation, so where you have an ongoing working relationship with partners. And I've just seen a question pop up about what about partners who don't inform us. I think that's where it goes to how you set up those relationships with your partners. And there's some separate sort of guidance from the Commission around where you work with partner organisations, be they charities or non-charities, or whether they are sort of national or international. And actually that considers sort of assessing the risks, and often we will expect some form of written agreement in place with a partner organisation, which will be proportionate to that kind of relationship that you have, which would include considering making if there is something that meets the serious incident kind of guidance and could potentially be a serious incident, then that is reported up to the charity. And those are the types of things that you want to be thinking about in this context when you're working with partner organisations, is sort of that kind of reporting structure whereby you will be notified if something potentially happens that may be serious enough or have an impact enough on the charity's activities for you to need to report it in your own respect. And often we're working with partner organisations that aren't charities themselves, and so this will be a relatively new and unknown duty for them. So it's sort of that explanation, being clear about what your expectations are, given you are, charities working in a much more regulated sector and have this sort of expectation from the Charity Commission. Tabitha, I think if we move on to the next slide, this is for you, unless there's some other questions that have come out of that I've missed.
There is one, but I'm going to pick it up in my bit.
Fabulous.
So, I know that those of you who are here are likely to be aware of the change in the Charities Commission's definition of safeguarding. In the old days, we used to think about safeguarding as being the protection of children and the protection of adults at risk. Unfortunately, I've just seen about the headset. I've requested one. I'm in a different office and one hasn't been provided. So I can leave the room to go and get one. So bear with me one moment and I'll see what I can do.
I'm happy to take any other questions in the meantime, if that's helpful. What does the Charity Commission do when they get the reports? Well, I'm going to come on to that a little bit. So rather than ruin the upcoming slides, we'll hold off for that one. Hopefully I'll pick that up once we've looked at the safeguarding incidents, and Tabitha has returned with her headset now. So hopefully she will sort this out.
I'm hoping. Is that any better for people?
You might need to change the source of where the sound's coming from, because I don't know if it's coming through your headset yet.
I
think that might be better. Do you want to see if that works now?
Can you hear me now?
I can hear you.
Excellent. Right, well, let's try it. As I said, the situation in relation to safeguarding is that it's moved very much beyond the protection of children and adults at risk, or what used to be called vulnerable adults. And what people tend to think about in the broader community if you talk about safeguarding. And the Charity Commission expect all charities to take reasonable steps to protect everyone who comes into contact with a charity from harm. That is a very broad duty. And yes, of course, it picks up protection of people from all forms of abuse and neglect. It involves protection of people from extremism and radicalisation, as we were just talking about. But it also involves duties such as protection from bullying and harassment, protection from discrimination under any of the aspects of the Equality Act. It covers data breaches, it covers health and safety issues. And of course, there was a question about that in relation to it. And more broadly, it covers actually the charity's culture if the culture is such that it may allow poor behaviour and poor accountability. So the Commission are looking through safeguarding from a very broad lens. And when they then talk about what they expect charities to report in safeguarding terms, they similarly talk in broad terms. So they talk about it not just being incidents of abuse or mistreatment or which result in significant harm, but also allegations. So they talk about that. They say it's not just if beneficiaries of the charity are harmed, it could be anybody who suffers harm. They do still refer to this concept of significant harm that Kate's introduced for us, and leave that definition to the charity to determine. But they go beyond just talking about significant harm to say, well, yes, we're talking about harm to people. That's what, you know, fundamentally we're looking to protect, but we're also talking about harm to reputation. We're talking about harm to the general trust and confidence in the sector. So we're talking about these things too, and that these are all factors that should be borne in mind. Now, most people say that they understand what is required when it comes to a safeguarding issue which relates to the charity's operation. Maybe it's an issue about one of your events, or an issue about staff. But what they perhaps find rather more difficult to articulate are those other types of issues which may involve people who come into contact with you. And an example might be where you have visitors who potentially come into contact with the charity. They maybe attend an event and it's nothing actually to do with the charity's staff that might mean that they suffer some form of harm. So there will always be issues that need to be thought about in that context, and you'll need to go through that same test, if you like, to work out what it is that you are concerned about, and whether that then meets the threshold for reporting. Now, one of the things that we're quite often asked in that context is, what happens if, for example, a member of staff or a beneficiary discloses abuse outside the charity, and you actually have a mechanism to manage that and support it, but they have suffered harm? So you are informed of that, aware of that. Is that reportable? And generally speaking, the guidance that we've got from the Commission, and there's a really helpful examples table, which we'll work through in a bit, will say, if it's not an action of the charity that's caused or contributed to that harm, then it's less likely to need to be reported. However, they do say that there can be some circumstances which haven't actually caused any harm at all, which need to be reported. So the allegations piece that we've spoken about, but also the near miss type scenario that we're particularly used to articulating in a health and safety scenario, where they say, well, do you know what? If there is a breach of procedure or policy, if there is a circumstance that caused a scare to the charity that could have caused a significant risk of harm, then you need to consider whether it's reportable in that context. So the question I've just been asked is, how does intimidation and early stages of bullying fit under this scope? And we've got a scenario actually which is going to cover that. So if I may come back to that, because one of the things that's really hard with any of the issues that we've been talking about this morning is drawing that decision-making process around when something is a serious safeguarding risk, when it's an allegation and it's not necessarily been investigated through to a finding, and how you manage that process. And I think it will always be a nuanced decision that needs to be made and taken, that you may make a decision as a charity that something isn't yet reportable, but you'll want to keep that under review. And I will come back to what we've said already, which is, if in doubt, then we would recommend an early stage report so the Commission are aware of it, and that you can then update later. Kate's talked a little bit about the need to particularly consider reporting in to the Commission in circumstances where you've made a report to another regulator. And it's never more apposite than it is when you're dealing with safeguarding matters. So matters that are referred into local authorities will often be, not always, but will often be reportable. And you need to be aware that there is a dialogue between the Charity Commission and local authorities. And if the local authorities aren't happy with the way in which the charity is managing a situation, they will often speak to the Charity Commission, who will then contact you proactively to ask for more detail. As with all safeguarding, the more that you can do to engage with the agencies responsible, the better. And generally, think about the Commission as yet another stakeholder in your response to an issue in that context. Okay, so I'm going to move on now. So Kate's going to talk about the how and the why, but we'll come back and explore this in a bit more detail with a staffing issue, which will hopefully address the question that's just been asked.
Great, thanks, Tabitha. So I think this will pick up on the question that came in previously around what does the Charity Commission do with the reports they get. So I think we start with why does the Charity Commission ask charities to report serious incidents? And I think to understand the why, we have to understand that the Charity Commission is a risk-based regulator. And by that, it means that it's constantly assessing and proactively looking at the risks in the sector in order to decide where its resources are allocated and to really kind of determine where it should focus any of its work. And it's also, I think, in this context, good to acknowledge that one of the Charity Commission's objectives is to increase public trust and confidence within the sector. And so then when we see the Charity Commission assessing risks and determining where it should focus its regulatory action, we should probably be aware that they're often doing that through what is essentially the public lens and this view that the public hold charities to a certain level of regard, and that should be upheld. And so in order to sort of carry out its functions as a risk-based regulator, it obviously needs to compile information and gather information on the sector in order to inform its approach. And serious incident reporting is essentially one of the ways in which it does this. It also looks at annual return reports, media coverage, information it gets from other regulators and other agencies, as Tabitha was saying, in terms of the information sharing. But its primary way is from charities themselves, is through this serious incident reporting. And through a serious incident report, the Commission will review the information provided, and it helps them to ensure trustees are complying with their duties. So by making a serious incident report, a charity is demonstrating that trustees understand their duties, and it's also an opportunity to set out the action taken and demonstrate that appropriate and reasonable steps are being taken to protect a charity's beneficiaries or its assets or its reputation. And again, that public perception piece comes into play there. A serious incident report also helps inform the Charity Commission in terms of using its regulatory powers or issuing statutory guidance. So by reviewing the information that it receives on a serious incident report, the Commission is able to determine whether they need to offer any further statutory guidance to a charity, or whether it's serious enough that they need to sort of use any of their regulatory powers and actually step in and take sort of more proactive steps in terms of taking charge of the situation. And it also uses serious incident reports to assess risks to other charities and the sector as a whole, and identify themes and trends of what's happening. So for example, if we take the donations piece that we talked about recently, if the Charity Commission was to receive a lot of serious incident reports about large unverified donations being received by charities, that would then inform its process and its focus in terms of, well, okay, maybe we need to provide some further guidance on how to deal with donations, or whether we need to take issue a regulatory alert to all charities saying they need to be aware of these certain risk factors when receiving donations. So that's sort of what it does. That's basically what it does with its serious incident reporting. And I hope that sort of answers the question. If we move on to the next slide, please. When should a report be made? And so this essentially is taken from the Charity Commission's guidance, and it says that you should report an actual or alleged incident promptly. This means as soon as reasonably possible after it happens, or immediately after your charity becomes aware of it. And I think there is some understanding from the Commission about the reality of serious incidents when they happen, and actually that will take management time within the charity, and it might not be an instantaneous process in terms of drafting a report, getting any advice you might need on that, getting trustees' input as and when required. And so there is some acknowledgement of the realities, but that doesn't take away from this sort of duty to make a prompt report. And I think one of the factors that charities should be aware of when thinking about the timings of report is that larger piece around whether there's been reports to other agencies which may share information with the Charity Commission, whether any incident is known publicly or is likely to be released in the media, therefore impacting the reputation. And those factors are important in terms of how quickly you may be making a report, because by making a report, you're in some senses being able to not control the narrative, but put forward the charity's narrative and the actions and what has been taken place before the Charity Commission has to come back and ask you. And so it very much allows a charity to sort of show the steps that are taken and be on the forefront on the, of that incident, rather than kind of chasing the tail in trying to satisfy the Commission's questions as an after effect. Obviously, there will be occasions where you have limited information about a serious incident, and that's often the case where there's some form of criminal allegation or safeguarding allegation, and there hasn't been enough time in which to be certain of the facts and what has actually happened, or even set up a plan about how to manage that incident. And in those occasions, we would often say, well, it may be worth making an initial report and being quite clear within your initial serious incident report that this is just an initial report. This has happened. We've had this reported to us. We will be taking steps to manage this and assess and review. But at this stage, we just want to let the Commission know that this has happened. And that can be a way to sort of open that conversation and show that trustees and the charity are aware of their duties without having to really have gone into the detail of the matter. So if we could just go on to the next slide, please. I think we've talked a lot about reporting and what significant might be, and actually assessing things within the context of the charity. And ultimately, the Charity Commission says it's the responsibility of charity trustees to decide whether an incident is significant and should be reported. And this can sometimes be quite difficult, and a lot of incidents are often relatively borderline as to whether they will be significant, or you don't at the outset know that they are going to lead to reputational harm, or things can sometimes snowball. Something quite innocent and mild and minor might happen, and then actually from investigation that then becomes much clearer that it's a bigger issue and much wider and more significant. And so it's that sort of ongoing review process that can be quite important. What's some guidance that is available on the Commission? And I'm not going to go into this into detail because I am slightly conscious of time, but within the how to report a serious incident guidance, which is the main piece of guidance from the Commission, there is a table, and the header of there is on the slides, which gives some examples of what is reportable and what isn't reportable. And actually that can be quite helpful in thinking about those more borderline cases and seeing sort of where the Commission has set its expectations. Can be quite helpful. So I think Tabitha already picked up on some occasions where something that is a safeguarding matter or is a complaint or grievance may not necessarily be reportable, but actually there is a point at which that may tick over into being reportable. So if you ever have any questions around kind of what is and what isn't reportable, I would suggest a starting point is that guidance there and those example tables as a first place to think about it. If we'd go on to the next slide, please. So talked about mostly the whys, the whats, the ifs and the buts, and now let's talk about how we would make a report. So the Commission, I think I sort of expect most people are probably aware, but the Commission expects you to make a report using its online portal. This is a relatively recent change over the last couple of years, and essentially what it means is that there's now a relatively prescriptive form within which you are needing to report serious incidents. And a lot of the questions are tick boxes or short answers that sort of funnel the serious incident into those categories that we've talked about. And a lot of the process of filling in this form is essentially to help the Charity Commission gather data on what it's considered to be important and what it wants data on. So where it's asking questions around whether policies and procedures have been followed, or whether there is a policy and procedure, that is an area that the Commission are interested in knowing about and interested in hearing responses on. And then the main body of the report is the ability to describe what has happened, what steps have been taken so far, and what steps will be taken to prevent matters in the future. And one point to bear in mind is the Commission's expectation is that all reports are full and frank. And this can be quite difficult in determining what you are going to tell the Commission and how much detail. And we should also bear in mind that the Commission's online portal has specific character limits that also include spaces. So it can be quite difficult to get everything into a nice, neat report for the Commission within its prescribed limits. One thing I think as a guiding point when you come to sort of preparing reports is thinking about, well, what are the key risks here of this incident, and what risks does the Commission want to know about? And they might be risks that haven't come out yet. They've not come out, but you don't yet know if they're likely to happen, but there's still a potential that might become a greater risk later down the line. And so the approach we generally take when we are drafting reports is to think about, well, what are the key risks here? And let's ensure that we have at least notified the Commission in some terms of what that risk is. So if it later comes to fruition, we're able to point back and say, well, actually, we were aware of this risk. It's been assessed and reviewed throughout, and we had notified you at the outset, and it wasn't a case of sort of brushing something under the carpet. The other key thing we find throughout reports is actually trying to demonstrate what is being done and the actions and the steps that are being taken in order to address and manage that matter. And so set out some points here around management of the matter that the Commission will be interested to hear about. And that is what actions have been taken to prevent and minimise further harm, loss or damage, whether reports have been made to the police or other relevant agencies, and we've touched on that earlier, whether any sort of agreed statements have been agreed to be made to stakeholders or the media, and that's going to be particularly relevant where there's going to be potential reputational harm. So are any sort of PR advice being taken? Will there be any sort of investigation? How are we going to review the situation, and what are we going to take from those lessons learned? And those are the key points that the Commission will want to hear about. In some circumstances, you're going to be limited on the investigation you can carry out internally. That if, for example, you've got a third-party regulator or the police carrying out an investigation, you should be looking to seek guidance from them as to how much of an investigation internally you can carry out, if you can carry out one at all. And so those relevant factors are things you're also going to be wanting to let the Commission know. It's also key to understand that the Commission should be kept updated, and that actually just one report is not often enough. You need to be aware that there's an ongoing duty to keep the Commission updated of significant changes and developments. If we just move on to the next slide, and then I think it's almost the end of my voice. We'll go back to Tabitha. So one recent development we have seen that I just wanted to pick up on is the inclusion of a trustee assurance within the serious incident report. And this basically means that all reports that are submitted, and this is new reports and updates, must make this tick a yes or no answer box to this question. And it says, are the charity trustees satisfied that the action taken in response to the incident gives them assurance that it's been properly managed, the appropriate organisations and or statutory bodies have been notified, and adequate procedures are in place to manage any live risks to the charity and people who come into contact with it through its work. And this assurance essentially echoes all of the points we've been talking about this morning in terms of how you manage a matter, those agencies, third-party agencies being notified, and managing any live risks. But the key difference here is actually the way this is phrased, and it's phrased as a charity trustee assurance, which to us very much indicates that the Commission want to see trustees' engagement and oversight with serious incident reporting. Slightly contradictory with its guidance, where it does acknowledge that delegation of serious incident reporting can be made to charity staff, and that is an acceptable process. But if you look further into the guidance, it does specify that, well, there should be a process for notifying trustees, and actually where you've got more borderline issues and decisions, those need to be considered by trustees, because it is ultimately a trustee duty to report serious incidents, not one for charity trustee staff. So this really has sort of brought up some questions around delegations and how serious incident reporting is managed. And often what we're now advising is that there is some trustee oversight, but it doesn't necessarily mean that you might need the whole board involved. And in some cases that's inappropriate, because you need to maintain some sort of independence or clean hands for further investigations, reviews of certain incidents. But that actually there should be a process whereby trustees have some form of individual trustees, be that one or two, have delegated authority from the board as a whole to sort of be reported to and satisfied about this trustee assurance, and to be making this trustee assurance before serious incident reports are put through. And there was a question earlier, I think, about where decisions are made about reporting or not reporting. And actually, one of the key points there is, if you have an incident that's happened and you decide not to report it, well, that should be minuted, and that should be considered by the trustees or whoever has delegated authority over that, so that in the event that something happens related to that further down the line, you're able, and the commission says, well, why didn't you tell us this earlier? You're able to look back and look at the reasons and the rationale for that decision, because ultimately it is, as I said multiple times already now, a trustee decision, and the commission can't impose a decision on you. They can't decide what a trustees board will have made, as long as it's within a reasonable sort of range of decisions based on the information that you have at hand, then that should be an acceptable decision. And so I think I'm going to hand back over to Tabitha.
Just before we move on to the case
Yes.
study, just a couple of issues to pick up on. One is a question that we had about the risk of over-reporting.
Mm-hmm.
All I can say about that is that we help an awful lot of charities to serious incident report. And I've never known a situation where a charity has reported and there has been concern by the Commission. The Commission's concerns have always been addressed when they learn of something which hasn't been reported, or where they're not happy about the level of information that's been provided. And thankfully, with our input, that hasn't materialised. The other thing to say is, they do recognise that certain charities are going to have a lot of reports, and they have a bulk reporting regime that is in place to help charities who may find that out. Kate, I mean, I think I'm right in saying your experience is the same, but please correct me if it isn't.
With the bulk reporting, or with
with the risk of over reporting?
No, I agree. I think we tend to find that it's more a risk of not reporting, and then that later being a later criticism from the Charity Commission.
And just to pick up on the next question that we had is information that we provide to the Commission subject to the Freedom of Information Act? Yes, it is. The Commission will be very careful about what they may disclose through it, and we put both Freedom of Information Act and data protection warnings on the reports that we submit for clients, so that we ask the Commission to refer back to us if they're thinking about referring to it, so that we can make representations in that respect, and that may be something you wish to do. Yeah. I am conscious of time, and what I'm going to do is, first of all, say thank you so much for those of you who do need to leave us. But for those of you who can stay, I'm going to spend another 5 minutes or so just going through a case study, which will hopefully bring some of what we've spoken about to light. So could we have the next slide, please? Okay, so this is a what would you do question, and it is hopefully going to pick up on the question we were asked earlier. What would you do if you had an employee who's off sick with stress and who has alleged that they've been bullied by their team leader. Would you make a serious incident report, or would you not at this stage? You should have had a poll pop up so that you can say yes or no. And the other thing to say within that is you'll note the wording that we put in the question, which is one that we recommend that you utilise, is that if you're making a decision no, I'd always say no, not at this stage. And I think that 92% of you said not at this stage, and I understand that. We mentioned the examples table. Now, the examples table does not cover every eventuality, but it does give you some useful guidance in relation to that. So one of the things that you might want to think about in this sort of scenario is whether it is significant harm. So you may want to find out a bit more about off sick with stress, how long, how severe the symptoms are, whether there are other factors that could be a part. So that would be one bit. They allege they've been bullied by their team leader. The wording of that suggests it's not yet been investigated, so no finding. And there is nothing in what I have said to suggest that the team leader is in fact somebody who's in a very senior position within the organisation, as perhaps the chief exec or the head of safeguarding, in which case you may take a different view. So if we move on to the next question. So now we're saying, okay, so there was an investigation done and it discovered multiple previous complaints of bullying within the charity, not all relating to the same employee or indeed in relation necessarily to the same victim, but allegations made against several members of the senior leadership team, and you've noticed that staff retention is poor. Does that change your answer? So at the moment we've got complaints, but we've not got findings. So are you going to make a serious incident report now, or again, not yet? So we've got 63% in favour of making one, plenty not doing so. And I think what is really important in that sort of scenario is that you are keeping a note of your decision making. I think either can be justified at this stage. I also would err in favour of reporting because essentially we've got a suggestion that there is a widespread cultural issue within the charity at this point. And we've heard what we've said about the Commission being interested in cultural issues, interested in allegations, and because this is against members of the senior leadership team, it's indicative of a widespread problem. And I think that if you made a report to the Commission and said, this has happened in the context of investigation of one individual issue, we have found out more, and we intend to look into that and assess it and take appropriate action. I think the Commission would say, right, we're happy with what's going on. Whereas if they find out about it later through another form, I think they would be critical, or there is a risk they would be critical of a failure to report at that stage. And if we move on to another aspect of that, so you have followed your internal process for investigating grievances, and the investigation has upheld the grievance. Does this change your previous answer? So if you were a no previously, would you do so now? We'll just wait for the answer a moment. I think this is interesting. So my first thought is, when you normally report to the Commission, they quite often use completely standard form replies. And one of their standard form replies of it requires trustees to essentially update them on any material developments. And I think a finding of bullying is something that would be a material development that is likely to be reportable. There is some nuance in all of this. Yes, I think that that I would have been reporting, I would have been recommending a report at stage 2 and an update at stage 3. I think it's open to you to either wrap it all up in a single serious incident framework and keep using the same reference, or to have separate ones, one about the cultural and one about the individual member of staff who's raised the allegation. I tend to prefer keeping them together where they are because of that concern that was raised earlier about the number of different things that you're reporting in, and because you discovered the concerns about culture through the lens of this particular grievance that was raised, but there isn't a right or wrong answer on that. We did have 6% of people saying they still wouldn't report to the Commission. It is a decision that is to be made by the trustees. So it is open to you to do that. It's for you to think about whether the threshold has been met and be able to justify it. What I would say is if you are not going to report, it's really clear that you demonstrate that you've been through the appropriate decision-making process, that you've looked at the guidance and the decision table, and you articulate why it is that you don't think that that is important at this stage. And I think that in terms of the wider allegation piece, what we are seeing from the Commission is much more expectation of investigation. So even if the wider allegation came about from a grievance, a personal grievance, I do think that you need to undertake a reasonable and a proportionate investigation of the wider issue. That hopefully will start to put things into some sort of context for you. Certainly in terms of serious incident reporting, the Commission in their examples table say that if you've done an investigation that establishes there's a widespread culture of bullying, then within the charity, then that should be reportable. So we have a little bit of time, and I've seen that there is some further comment. One is about how this fits with reporting to the Scottish regulator, and I'm afraid that's not something that's within the remit of this one. Another is what happens if you don't have a good policy and procedures framework to be able to identify all of that. And I think that what will happen when you do a serious incident report and you go through the framework is if you identify that there is a problem because you don't have a framework to investigate these things, and quite often we see that actually about complaints that aren't perhaps within the framework of staff or beneficiary type scenarios, then that should be considered of itself as something that may be reportable to the Commission in terms of the issue I said at the beginning in safeguarding terms about the adequacy of policies and procedures. Now, there is a little bit more just to say in terms of how we might be able to help. The first thing is that the Commission, the Serious Incident Reporting Portal, doesn't allow you to save it, extract it, get the right sign off, and then submit it. And we have extracted the portal questions and created a Word document of those. It's quite an issue to maintain, actually, because they change it quite often without giving any notification that they're doing so. And we circulate that and maintain it within a serious incident reporting pack that we have, which has those aspects. It also has a suggested delegation framework so that you can show that there's a clear and readily understood framework between the governance of your charity and your executive, those who are running it, about decision making. And it's also got a suggested framework for maintaining a record of your decision making. So if we move on to the next slide, this will be within the slide about the guidance that we've spoken about, and on again. We've talked about the pack, so if you would like further information about that, do please let us know and we'll be in touch. And if not, then understood. We do have some useful guidance on our website, which is separate from that, so do please think about contacting us for that. And otherwise, thank you so much for joining us. And in particular, thank you for bearing with us for the sound issues, which we will resolve for the future. And thank you for your engagement this morning.
Yes, thank you, everybody. And I think we're going to be sending around the slides after the event, so that also has my contact details and Tabitha's contact details. So if you have a question that you'd like to ask us as a follow-up, please do just drop us a line. We'd be very happy to help. And as I just echo what Tabitha says, thanks for coming and bearing with us with our headset issues.